My HOA president hacked the community Wi-Fi and secretly spied on 14 families, including mine. Every website, every late-night search, every private medical question, all logged. Charlene searched how to sell my house fast on a Thursday night. Friday morning, Diane called her realtor and threatened her with fines. The Gutierrez family searched for schools for their disabled son. That search ended up on a USB drive in Diane's cardigan pocket. I ran a routine network scan on a Tuesday night. I sat there, didn't move. 10 seconds. Then I said out loud to no one.
I know exactly what you did, Diane. You just hacked the wrong neighbor. You have absolutely no idea who you're messing with.
Because for 11 years, I didn't just use surveillance networks. I built them. For Pentagon black sites. She started this war without knowing I designed the weapons. What would you do if you found out your HOA president was spying on your entire family? Drop where you're watching from. How far has this story traveled? Let me back up. My name is Marcus Webb, 44 years old, recently divorced. One daughter, Callie, who splits her weeks between my house and her mother's. She's 14, plays soccer, and has strong opinions about everything except which parent's house she prefers, which she keeps carefully neutral. I respect that about her. My job title, if you asked most people who know me, gets summarized as something with computers for the government, which is technically accurate the way saying Niagara Falls is something with water is technically accurate. For 11 years, I worked for a defense contractor outside Washington, D.C. My actual job was designing secure network architecture for classified facilities, the kind that don't appear in public procurement records, whose physical addresses require a clearance just to know, and whose security requirements make a bank vault look like a screen door. Hardened fiber optic rings, multi-layer encryption, traffic monitoring systems that could identify a compromised device within milliseconds, and isolate it before a single unauthorized packet escaped the perimeter. I was good at it. I was very good at it. When I left, I wanted the opposite of that. I took a quieter role managing network security for a mid-sized logistics company in Columbus, Ohio. Good work, reasonable hours, no classified anything. And I found a house in a subdivision called Whispering Pines Estates, about 40 minutes outside Columbus. The kind of neighborhood where the houses are just different enough from each other to feel personal, but similar enough to feel safe. Vinyl siding in 4 approved colors, concrete driveways, oak trees all planted the same spring in 1994, lined up like soldiers along streets named after things that aren't actually in Ohio. Aspen Court, Magnolia Drive, Blue Ridge Loop. I remember the first afternoon I moved in, late August. The smell of fresh-cut grass and someone's charcoal grill 3 houses down. The dry heat rising off the blacktop in that particular way Ohio blacktop does at the end of summer. I stood in the driveway with boxes, still in the truck, and just breathed. This is going to be fine, I thought. This is exactly what I wanted. I was right about what I wanted. I was wrong about what I was walking into. Diane Pruitt was the HOA board president, had been for 7 years running, not once interrupted by anything resembling an election. Mid-50s, hair that never moved regardless of weather, a smile that switched on and off with fluorescent light precision, depending on whether you were handing her a check or questioning a decision. The board had 3 seats. Diane held 1. Her longtime friend Roberta Shea held the 2nd, and had voted against Diane exactly 0 times in 4 years. The 3rd seat belonged to a retired postal worker named Gerald Fitch, who showed up to every meeting, nodded at regular intervals, and left approximately 12 minutes early. Annual elections were written into the HOA bylaws. Somehow, 7 years running, they kept not happening. 6 weeks after I moved in, I received my first notice. My satellite dish, legally installed, properly bolted to my own chimney, was in violation of HOA aesthetic guidelines because it was visible from the street. I looked up the relevant law that same evening. The FCC's over-the-air reception devices rule, a federal regulation, explicitly prohibits homeowners associations from restricting satellite dish installation in ways that impair reception. The rule cites specific case law. It is not ambiguous. I wrote back to Diane citing the regulation by full name, CFR citation, and the specific subsection that applied. She did not respond. 2 weeks later, a second notice arrived. My mailbox post was non-standard. The approved replacement mailbox, she noted helpfully, was available through a linked vendor website. The vendor was Pruitt Home Goods, LLC. Same last name, different first initial. I threw the notice in the recycling. I didn't say a word to anyone, but something had shifted in the back of my mind. That particular low-frequency alertness that develops after 11 years of thinking adversarially about networks and the people who try to compromise them. I started paying attention. The fines started arriving in October. Not one, a cascade. In a single calendar month I received $50 because my trash cans were visible from the street for more than 1 hour after collection. I had been at work, no one had called or texted, and the notice included a timestamp so specific it had to have been personally observed. $50 again 4 days later, same violation, same specific time format, same situation where I had been at work. Then a notice about my garden hose reel. Green, which is not an approved color under HOA guidelines. Approved colors were black or tan, information that appeared nowhere in the documentation I received at closing. Then a 2-page formal report, complete with photographs and measurements taken with an actual measuring tape, documenting a dead patch of grass on the south-facing side of my front lawn. I paid every single one, not because I believed I owed them, because a civil litigator named Patricia Hensley, a friend from law school days, now practicing in Columbus, had told me long ago, when someone wants a fight, don't give them the fight they're looking for on the schedule they've planned. Document everything. Keep your head down. Let them overreach. The overreach always comes. I started a folder. Paper copies and digital, encrypted, backed up. My neighbor across the street, a contractor named Vince Okafor, appeared at my door one Thursday evening with 2 beers and an expression that combined genuine sympathy with something darker, the particular look of a man who has watched this movie before and knows how it usually ends. She picks someone, Vince said, handing me one of the bottles, and she doesn't stop, not until they leave. Why? I asked. He shrugged. Because she can. Because in 7 years nobody has made it cost her a single thing. The beer bottle was cold in my hand, the glass slightly slick with condensation. I turned it slowly, thought about the mailbox vendor, about Gerald nodding, about the timestamps on the trash can notices, down to the minute, more precise than casual observation. Okay, I said. The following week I filed a formal public records request with Franklin County for HOA financial disclosures. Ohio law requires nonprofits, which HOAs are typically organized as, to make financial records available to members upon written request. In 7 years of board meetings, Diane had never once distributed a financial statement or budget report to the community. The request sat unanswered for 30 days. 30 days is the statutory maximum response period under Ohio public records law. So I filed a complaint with the Ohio Attorney General's charitable law section. I did not announce this. I filed it, noted the case confirmation number in my folder, and went back to coaching Callie's soccer team. Meanwhile, Diane had not stopped. A notice arrived claiming my back porch light, facing my own backyard, visible to no one but me and whatever raccoons were working the neighborhood, violated a light pollution addendum to the HOA rules. I requested a copy of this addendum in writing. She sent a document dated 3 weeks prior to my request. I cross-referenced it against the original CC and R documents from my closing package. The addendum had not existed in the original documents. She had written new rules retroactively, and was enforcing them as if they had always been there. I added the comparison to the folder, with the original CC and R timestamp, and the new document's date highlighted side by side. That same week I drove to Walmart and bought 4 wireless security cameras, $30 for the pack, the kind anyone can purchase without a second thought. I installed them on my driveway, front door, and both visible approaches to my mailbox. I didn't hide them. They were plainly visible from the street. Cameras on camera duty, which I found privately amusing. 2 neighbors across the way watched me install them from their own driveways. Neither said a word. Both gave me small, deliberate nods. The fines kept arriving. But they started getting sloppier. A trash can violation cited a Wednesday. Trash collection in Whispering Pines happened on Thursday. She was fabricating at least some of the documentation and losing track of the details. From that point forward, I photographed my trash cans at the curb and then back in the garage after every single collection day. Time-stamped, cloud-stored, cross-referenced with the collection schedule. There is a specific mental shift that happens when someone with a background in adversarial network security turns that framework toward a neighborhood dispute. The threat model relocates, but the methodology stays the same. You stop being reactive. You stop letting the other party set the tempo. You start asking the structured questions. Who has motive? Who has access? Who has control? And, most critically, what does the adversary not know that you know? Diane had motive. Financial, based on the vendor relationship. She had control. The board, the fines, the rules she was inventing. She had enforcement capability. And she had an information advantage that was too consistent and too precise to be explained by ordinary observation. The grass complaint had included photographs from an angle only accessible from behind my back fence line. The trash can timestamps were specific to the minute. She knew things she shouldn't have known, on a timeline that didn't fit casual surveillance. She was watching somehow. I just hadn't found the mechanism yet. That was coming. The Whispering Pines community Wi-Fi was something I'd registered as a minor technical footnote when I first moved in and had not thought about since. A shared wireless network, officially purposed for the pool area, the small clubhouse building, and the common green space in the center of the development. Set up 4 years prior by a local IT contractor named Dale, who had charged the HOA $800, installed a consumer-grade wireless router in the clubhouse utility room, given Diane the admin password written on a post-it note, and considered the job complete. The network barely reached the pool deck. Nobody in the neighborhood used it for anything meaningful. It was just a name that appeared in your Wi-Fi list when you were close enough. Except, when I moved in and did my initial passive scan of the wireless environment around my house, something I do by reflex the way a mechanic listens to an unfamiliar engine, I noticed the network's signal strength was slightly more robust than a single consumer router in a utility room should produce. Not dramatically, just enough to register. I filed it as probably a firmware update or a newer router model and moved on. 14 months later, on a Tuesday night in February, I was reconfiguring my home network setup for a quarterly security audit my employer required. Routine. I ran a standard passive network scan as part of the process, mapping the wireless signal environment, checking for interference sources, nothing exotic. The Whispering Pines HOA network appeared in the scan. I looked at the result for a moment. Then I looked harder. The network was running a minimum of 3 signal extender nodes. I could identify them by their MAC address patterns and signal characteristics. That was not consistent with a single router in a utility room. That was a deliberately extended network with significantly expanded coverage radius. One of those extender nodes had a signal origination point that placed it somewhere on the 500 block of Magnolia Drive. My block. I pulled up the router's administrative login page. The default gateway address, findable in 30 seconds on any consumer router's documentation page, and confirmed that the admin credentials were still set to factory defaults. Dale had never changed them after installation. I did not log in. I want to be precise about that because it matters legally. I documented what I could observe through entirely passive means. Signal characteristics, channel frequencies, MAC address ranges, the network topology is visible from outside. And I closed my laptop. Then I sat at my kitchen table for a while and thought carefully about what I was looking at. Here is the thing about network surveillance. Actual surveillance, not the Hollywood version with blinking screens and dramatic music. It always leaves artifacts. Every monitoring operation generates its own metadata. Logs of what was captured, when it was captured, from which devices. If someone had extended this network and was running a traffic interception operation through it, there would be a record of the interception itself, not just the captured data. And if the device running that operation was as poorly secured as the router clearly was, those records might be sitting completely unprotected, waiting for someone who knew where to look. I called Patricia that evening. I walked her through the technical picture first, then translated it into plain language. She listened without interrupting. When I finished, she asked 4 questions, each more specific than the last. Then she said, "If what you're describing is accurate, she's violated the Electronic Communications Privacy Act, federal statute. Civil damages start at $10,000 per violation. Does that mean per device monitored or per person affected?" I asked. A pause on the line. "Marcus," Patricia said carefully, "how many households are we potentially talking about?" "Based on effective signal coverage radius from those extender positions, 14, give or take." A longer pause. "Don't touch the router," she said. "Don't log in, don't access, don't change anything. I'm going to make a call." The call Patricia made was to a contact at the Ohio Cyber Crimes Unit, a state-level enforcement division that handles, among other things, unauthorized computer access and electronic interception cases. She didn't file a formal complaint, just a preliminary inquiry, enough to open a conversation with the right people. While that conversation was starting, Diane kept moving. Vince received a fine for a basketball hoop in his driveway, one that had been there, unchanged, for 2 full years without comment. Charlene Dupree, on Blue Ridge Loop, received a formal notice that her late husband's garden shed violated setback requirements. That notice arrived exactly 3 weeks after Charlene had mentioned at the grocery store that she was thinking about selling the house. And my own personal home internet service, my private residential account, completely separate from the HOA network, began dropping packets at irregular intervals. Not enough to be obvious, precisely enough to be annoying if you were the kind of person who monitored your own network traffic. I was exactly that kind of person. The drops had a pattern. They weren't random signal noise. They correlated with specific time windows. Early morning, late evening, the periods of highest residential internet activity. The same windows when most of the neighborhood would be home and active on their devices. I logged every drop, time-stamped, cross-referenced with time-of-day patterns. I did not change my behavior. I did not vary my routine. I did not let on that I'd noticed anything. Because revealing to an adversary that you've identified their surveillance operation is the single fastest way to watch them go dark and destroy evidence. The only way to capture someone in the act is to let them keep acting. So I let her. Spring came to Central Ohio the way it always does, reluctantly, with 2 false starts and 1 surprise frost in late March that killed half the neighborhood's early tulips. The wet soil smell when it finally committed, something sharp and green underneath it. A neighbor's dryer vent carrying fabric softener across the cul-de-sac at odd hours. I had spent the winter building. The folder, now a digital archive, encrypted, backed up to 2 separate locations, contained 14 violation notices with verifiable errors or fabricated details, the retroactive rule addendum with the original CC and R documents showing it hadn't existed, the Ohio AG complaint confirmation and case number, the packet capture device network scan documentation, time-stamped and technically annotated, Patricia's preliminary legal memo outlining potential federal civil exposure, and a growing log of personal network anomalies with timestamps and patterns. I had also been talking to my neighbors, not in groups, one at a time. Fence lines and driveways and the parking lot of the Sunoco on Route 40. Carefully, quietly, and only when I was confident the conversation wouldn't get back to Diane before I was ready. Vince already knew the technical picture. When I walked Charlene Dupree through what I'd found, the network topology, the signal extenders, what a packet capture device does and what it would have captured, she went quiet for a long time. Then, in a voice that was very controlled, very deliberate, she said, she knew I was thinking about selling before I told anyone. She called my realtor the next day. My realtor called me confused, said the HOA president had been in touch about my property. I hadn't listed it. I hadn't told anyone except I'd Googled it on my home Wi-Fi. She looked at me steadily. That's how she knew. Derek and Susan Parrish on Aspen Court had been receiving fines for 3 years. They had never compared notes with anyone else in the neighborhood because they'd been too embarrassed. We genuinely thought we were doing something wrong, Susan said. Like we just didn't understand the rules and everyone else did. The shame in her voice, specific, familiar shame, the kind that comes from being made to feel like the problem, made me quietly and thoroughly angry in a way the fine notices themselves had never managed. Raymond Kowalski had lived in Whispering Pines since the development was built. He was 71 years old, measured, and had attended every HOA meeting for 6 years without once making a fuss. He sat with everything I told him and shook his head slowly. I remember when she organized the Christmas cookie exchange, he said. Before the divorce, she knew everyone's kids' names. She was a different person. He paused. But I didn't know it had come to this. I asked everyone the same things. Keep every violation notice. Document every unusual interaction. Say nothing to Diane or the board. I asked for patience. I got it. What I was building, methodically, was a structure I knew from a completely different context. A network map, not of computers, but of witnesses, documented grievances, and legally demonstrable harm. Every node connected and corroborated. Every data point supported by at least one independent source. Then Diane made her most aggressive move. In March, a new CC&R amendment appeared, allegedly passed at a board meeting that no residents had been notified of, which was itself a procedural violation, requiring all home-based businesses to register with the HOA and pay a monthly operating fee of $200. I worked remotely for my logistics company. Derek Parrish did freelance graphic design from his home studio. Charlene sold handmade candles through an Etsy shop she'd started after her husband passed, which she'd mentioned exactly once at a neighborhood gathering the previous fall. Patricia confirmed within 24 hours. The amendment was almost certainly unenforceable under Ohio law, which has consistent case history rejecting HOA restrictions that function as business licensing. The procedural failures alone, no member notice, no proper vote record, would void it in any competent court. But fighting an invalid rule still costs money and time and stress, which was entirely the point. I paid the fee, certified mail, return receipt requested, full paper trail. Then I filed a complaint with the Ohio Secretary of State's office, alleging that the HOA, operating as a registered nonprofit, had failed to provide statutory notice of board meetings, failed to conduct required annual elections, and was operating under a board that had not been legitimately reseated in over 3 years. Under Ohio Revised Code, the Secretary of State can order a nonprofit corporation to conduct new elections under state oversight. 2 days after that filing, a certified letter arrived from a Columbus law firm. 8 pages. The word egregious appeared 4 times. Diane was threatening to sue me personally for tortious interference with HOA operations and defamation. I read the letter once, set it on the kitchen counter, poured 2 fingers of bourbon, called Patricia. She lawyered up, I said. Good, Patricia said. Scared people make mistakes. Letter. I looked out the window at the oak trees, all the same height, in their soldier-straight row, lit gold in the late afternoon. Uniform. Controlled. The way everything in Whispering Pines was supposed to look. One more escalation, I thought. Give her one more. The Ohio Cybercrimes Unit took 3 weeks to respond to Patricia's inquiry, which is not a long time as government agencies go. When they did, it was to request a meeting. Not a formal interview, just a conversation. I drove to Columbus on a Wednesday morning and spent 2 hours with a detective named Hugh Garrett, fleece vest over a button-down, the precisely calibrated politeness of someone who is excellent at their job and has been for long enough that they no longer need to announce it. What Detective Garrett laid out for me rearranged everything. The HOA network had been significantly modified from its original single-router configuration. Dale's consumer router was still physically in the clubhouse utility room, but it was now operating as a secondary device, feeding traffic through a more sophisticated network appliance that had been physically installed in the same room at some point in the past 2 years. The appliance was configured as a transparent bridge. This means traffic passing through it was invisible to standard network diagnostic tools. It appeared simply as part of the normal network infrastructure, producing no obvious signature. It was running packet capture software. Specifically, it was logging DNS queries from every device that connected to the network, and from devices that had been silently associated with it through signal overlap and aggressive SSID broadcast techniques, and writing 90 days of logs continuously to an attached USB drive. In plain language that anyone can act on, every website address searched by every device in signal range. Stored. Organized by device. Retrievable. Sitting in Diane Pruitt's physical possession on a drive small enough to fit in a jacket pocket. 14 households. The detective had located the device based on an anonymous tip that arrived with enough specific technical detail, channel frequencies, MAC address ranges, precise extender placement coordinates, to justify an inspection warrant within 48 hours of receipt. The tip had not come from me directly. I had provided documentation to Patricia. She had communicated it through appropriate legal channels. Somewhere in that chain, the right information had reached the right person. I didn't ask who made the anonymous call. I had a reasonable working theory. The packet capture logs told a story that was stunning in its pettiness and its violation. Charlene Dupree's browsing history included real estate research and estate planning searches spanning several weeks, which is exactly how Diane had known she was considering selling before Charlene had told a single person. Derek Parrish's logs showed searches related to a specific freelance client project, the origin of the home business fine, and the Gutierrez family on Aspen Court had spent several evenings researching special education placement options and disability accommodation resources for their son. That family's most private and vulnerable research had been sitting on a USB drive in Diane Pruitt's cardigan pocket. Federal law on this point is not subtle or complicated. The Electronic Communications Privacy Act, 18 U.S.C., Section 2511, prohibits the intentional interception of electronic communications. The network having a community use name is irrelevant. The router being in a shared physical space is irrelevant. Intercepting private communications without authorization and without consent is a federal felony, regardless of the mechanism or the setting. The practical takeaway for anyone watching: connecting to a Wi-Fi network with a public or community name does not grant the operator any legal right to intercept and log your traffic. That requires explicit prior disclosure and affirmative informed consent. Without both, it is a federal crime. I drove home from Columbus with the windows down, rain coming from the west. I could smell it an hour before it arrived, that particular electric wet scent that precedes a serious storm. I thought about Charlene, about the Gutierrez family, about Derek and Susan standing in their driveway looking embarrassed, like they'd done something wrong. They hadn't done a single thing wrong. Now, I thought, now we build the trap. 3 weeks, that was the build time. I've planned operations before, not HOA operations, obviously, but the rhythm is the same regardless of scale. You identify your objectives clearly. You sequence dependencies so nothing downstream fails because something upstream wasn't in place. You document every step because documentation is simultaneously your protection and your weapon. And you do not move until the architecture is solid, because a half-built trap is worse than no trap at all. The legal architecture came first. Patricia had brought in a second attorney, Oscar Tran, a civil litigator in Columbus who specialized in consumer protection law and had handled 2 prior ECPA cases to successful conclusions. Between them, over several long evenings in Patricia's conference room, with bad coffee and good focus, they built a federal civil complaint naming Diane Pruitt as an individual defendant and the HOA as an entity defendant. The claims were layered deliberately: ECPA violations as the primary federal count, Ohio nonprofit governance failures, the election irregularities, the procedural violations, the lack of financial transparency, the fraudulent vendor arrangement with Pruitt Home Goods LLC, which constituted self-dealing prohibited under nonprofit law, and what Oscar characterized as a documented pattern of targeted harassment against specific residents that rose to the level of intentional infliction of emotional distress under Ohio tort law. Oscar explained the filing sequence to me with the patience of someone who genuinely enjoys his work. You don't fire everything simultaneously. You fire in sequence, forcing a response to each action, watching each response consume resources and close options. The Secretary of State complaint was already in process. That one forced an election under state oversight and stripped Diane of board authority. The AG complaint was running in parallel. That one threatened the HOA's nonprofit status and triggered financial scrutiny. The federal civil complaint would be the final piece. Time to arrive when Diane's legal budget had already been depleted responding to the state-level actions and her board position had been eliminated. "We close every exit before she knows she's in the building," Oscar said. "I understand the concept," I said. He smiled. "I figured you might." Meanwhile, I spent time doing something that cost nothing but required care. I sat with my neighbors and explained, plainly and technically, what had actually been done to them, one house at a time. Coffee at kitchen tables, or standing in side yards in the April chill. I explained what DNS logging meant in practice, what packet capture software does, what 90 days of stored browsing history represents. I explained clearly and without drama that what had happened to them was not an aggressive HOA dispute or a personality conflict with a difficult neighbor. It was a federal crime committed inside their homes, against their families, using their own internet activity as a weapon. Raymond Kowalski, retired, measured, a man who had attended every HOA meeting for 6 years without once raising his voice, said something I will not repeat here. Then he straightened in his chair and asked where to sign. Charlene wiped her eyes, squared her jaw, and asked the same question 90 seconds later. 9 families signed the joint victim statement. 4 agreed to attend the annual meeting in person. The physical component of the trap was the most technically satisfying piece. The packet capture device was still in the clubhouse utility room, behind the folding table, exactly where Diane had left it. It was still operational. Detective Garrett's team had examined it under the inspection warrant and left it physically undisturbed. Working with the detective and his technical staff, I arranged for one modification, a firmware-level logging enhancement that would record every subsequent access event to the device, including any attempt to connect external storage, modify configuration, delete logs, or physically remove the unit. Any such event would be automatically documented, and the record transmitted to a secure remote server in Columbus within seconds of the action. Evidence tampering is its own distinct federal offense under 18 U.S.C. Section 1519. You only need the subject to try once. The trap doesn't have to stop them. It just has to record them. The annual meeting was set for the second Saturday in May. The Ohio Secretary of State had issued a formal compliance letter under ORC Section 1702.38, requiring the meeting to include board elections under independent oversight. A state-appointed election monitor, retired Judge Barbara Ellison, would be physically present. I called Tanya Voiles at the Columbus Dispatch. She covered HOA stories. When I finished explaining what the USB drive contained, she went quiet for a moment. Then she asked for my encrypted email address. I sent her everything. Her story would publish online at 7 a.m. on the morning of the meeting. There was one more piece. I had reached out to Roberta through Patricia, carefully, through proper channels, with full documentation in hand. I showed Roberta the logs, including the data captured from her own household's devices, private searches, personal browsing, all logged without her knowledge, by the woman she had voted with without question for 4 years. Roberta sat with that information for a long time. Then she said she needed to call her son. Her son was an estate planning attorney in Cincinnati, who had done one HOA case in law school, and remembered it well enough to give his mother very specific advice about her personal legal exposure as a sitting board member who had become aware of a federal violation. 3 days later, Roberta confirmed she would attend the annual meeting. Independently, she would not be coordinating with Diane. The exits were closing. 2 weeks before the meeting, Diane sent her counterstrike, certified mail, return receipt requested. She'd learned that much from watching me. Formal notices to me, to Vince, to Charlene, to Derek and Susan, and to Raymond, each assessing special fees for unreimbursed HOA administrative costs arising from our pattern of disruptive conduct toward the board. The fees range from $340 to $890, depending on the recipient. Each notice stated clearly that the fee would become a lien against the property if unpaid within 30 days. She had chosen her weapon carefully. An HOA lien in Ohio is not abstract. It attaches to your property title. It appears in title searches. It can delay or complicate a sale, trigger lender notifications, and, in cases pushed to their extreme, initiate foreclosure proceedings. Most homeowners, confronted with a lien threat, will pay almost anything to make it disappear. Patricia reviewed the notice that same afternoon. Her conclusion: the HOA had no governing authority to levy administrative cost fees against individual members without a specific provision in the CC&Rs authorizing such fees, which did not exist in any version of the documents, and without a properly noticed board vote, which had not occurred. Any liens filed under this notice would be voided by a court on multiple independent grounds. But voiding them still costs time and money, I said. Yes, Patricia said. That's the calculation she's making. 3 of the 9 families in the joint statement asked to have their names removed. I removed them without discussion or pressure. I understood completely. These were people with mortgages and jobs and limited capacity for open-ended legal exposure, regardless of how solid our position was. 6 signatories remained. Then Diane called a special board meeting. 3 days' notice, the bare statutory minimum. The agenda: an emergency amendment to the HOA bylaws, extending the current board's term indefinitely, pending legal review of election procedures, required before complying with the Secretary of State's compliance letter. It was a transparent attempt to delay Barbara Ellison's appearance at the annual meeting by manufacturing procedural uncertainty. The amendment was passed. Roberta voted yes, which I noted carefully. Roberta was still playing her role publicly, while privately already switched, and filed with the Secretary of State's office as the basis for a delay request. I forwarded the full amendment documentation to the Secretary of State's compliance officer that afternoon. The officer called Patricia 2 days later. In a tone Patricia described to me as professionally displeased, she confirmed. The amendment had no legal effect on the state-ordered election requirement. ORC Section 1702.38 is not superseded by internal bylaw amendments. The meeting would proceed as scheduled on the second Saturday in May. Judge Ellison would be present. Then Diane tried something more personal. She appeared at Raymond's front door on a Tuesday evening with a plate of cookies and a carefully rehearsed speech. Raymond texted me from inside his kitchen while she was still on his porch. Real-time, dry, with the slightly bemused tone of a man who has seen more in 71 years than most people encounter in 2 lifetimes. She says you're using the neighborhood for a personal vendetta. I texted back. Screenshot anything she sends you. She's offering to drop my fines if I stay home Saturday. That's an attempt to influence a witness in a pending legal matter. Don't accept anything. I know how to handle a bribe, son. A pause. Then, the cookies are genuinely good though. I set my phone down and allowed myself 1 moment of actual amusement. Raymond ate 2 cookies and confirmed his attendance at the meeting. Diane's final pre-meeting move was the one that confirmed everything and changed nothing, because I had already prepared for it. 4 days before the annual meeting, at 11:17 p.m., her access badge registered at the clubhouse utility room door. The keypad entry system logged the swipe, the time, and the duration. 9 minutes inside. When she left, the packet capture device was physically undisturbed. The USB drive was still plugged in. Nothing visible had changed, but the firmware logging system had recorded every second of those 9 minutes in forensic detail. She had connected an external drive. She had attempted to download the stored packet capture logs to it, presumably to destroy them before the meeting. The download had failed. Detective Garrett and I had modified the device's export permissions so that data extraction required authentication by the detective's designated forensic recovery tool. She had tried to delete the evidence. She had failed. And now there was a documented federal evidence tampering attempt, 18 U.S.C. Section 1519, sitting in a time-stamped log file on a secure server in Columbus, cross-referenced with her badge entry record, waiting. I looked at the notification on my phone, set it down on the kitchen counter. 1 week. The final week before the annual meeting had a specific quality to it that I recognized from other contexts. The held-breath stillness of a fully set operation waiting to execute. Everything on the surface completely normal. Underneath the surface, every component in place, every dependency confirmed, every contingency documented. I coached Callie's soccer practice on Tuesday and Thursday evenings. She was working on her left foot shot, which had been inconsistent all season, and by Thursday, something clicked, and she put 3 in a row exactly where she was aiming. I felt disproportionately good about that. Some weeks, you need the small victories to feel real. I grilled on Saturday afternoon. Burgers, slightly overcooked because I was distracted, which Callie pointed out with the specific precision teenagers reserve for their parents' minor failures. The lawn was 3.5 inches. I had been maintaining it at 3.5 inches for 2 months. Not because of any rule, because I could. Tanya Voiles texted me the final headline on Wednesday. Columbus area HOA president accused of illegally spying on 14 households. Her editor had cleared the full piece. It would go live at 7 a.m. Saturday. I read the headline twice, then put my phone in my pocket and went back to what I was doing. Oscar had the federal civil complaint formatted, reviewed, and queued for electronic filing. 23 pages, 6 named plaintiffs, 2 defendants, Diane Pruitt individually, and the Whispering Pines Homeowners Association as a corporate entity. Filing time, 9:45 a.m. Saturday, 15 minutes before the meeting started. Not accidental. Detective Garrett confirmed he would be present at the meeting in plain clothes. There was sufficient evidence in the file to justify observation and, if certain statements were made in a public forum, potentially a voluntary interview request. He'd been clear with me in our final call. Nothing at that meeting happens because you caused it. You present documented facts. You let the legal process do its work. I had agreed to that completely and sincerely. Not because I was told to, because it was correct. The entire structure I'd built was designed to be self-executing. I didn't need to do anything dramatic on Saturday. The systems would run. The night before the meeting, Vince came over with 2 beers. Same brand he'd brought the first time, 14 months earlier, when he'd knocked on my door to warn me about Diane. It felt like a much longer time ago than that. We sat on the porch and watched the evening settle. The oak trees in full leaf now, that deep mid-May green that makes Ohio almost beautiful after a long winter. The air was warm and soft, the faint smell of somebody's grill a few houses down, a sprinkler system running somewhere on the next block. "You think she actually shows up Saturday?" Vince asked. "Yes," I said, "even knowing what she knows?" "She doesn't know everything she's walking into," I said, "but more than that, 7 years. She's been the most powerful person in that room for 7 years. And before that, she was one of those people who organizes things and makes the neighborhood run, and everyone is grateful. That doesn't just switch off. People need to feel like they still have a version of what they built, even when the evidence says it's already gone." Vince was quiet for a moment. "What about Gerald?" he asked. "Gerald votes with whoever controls the room. By 10:15, that won't be Diane." "And Roberta?" "Roberta switched 3 days ago. She didn't know about the packet capture. When I showed her that her own family's browsing data had been logged, her own private searches, sitting on Diane's drive without her knowledge, she sat with that for a long time. Then she called her son." I looked at Vince. "Her son is an attorney in Cincinnati who did one HOA case in law school and gave his mother very precise advice about what failure to report a known federal violation means for a sitting board member's personal liability." Vince stared at me. Then he started laughing, not loud, just that low, genuine laugh of someone who didn't see a thing coming. "Roberta's son is an attorney, estate planning primarily." We sat with that. Inside, Callie was finishing homework at the kitchen table and calling questions about reconstruction through the screen door at intervals. The neighbor's corgi, a round, opinionated animal named Biscuit, was barking at something in the hedge line with the conviction of a dog who has never once been wrong about hedges. Everything was entirely normal. That's what patient, systematic work looks like from the outside. No visible tension, no dramatic build, just the evening and the trees, and my daughter asking about the 14th Amendment, and tomorrow morning everything arriving exactly where I'd placed it. I went inside, helped with the 14th Amendment, went to bed at 10:30. The second Saturday in May came in clean and blue and warm. 64 degrees, light breeze, that particular Ohio spring sky that seems almost aggressively clear after a long winter of gray. The gravel on the path to the clubhouse crunched under my shoes, dry and decisive, a sound I've always found satisfying in the same quiet way I find a well-written log file satisfying, things confirming themselves. I arrived at 9:50. The parking lot had 22 cars, more than any annual HOA meeting in the history of Whispering Pines, by a significant margin. I recognized most of the vehicles. People who hadn't attended a meeting in years. A few I was almost certain had never come to one before. Word had traveled, not through any announcement I'd made, but through the organic spread of 6 years of accumulated grievance, finally finding a credible direction. Tanya Voiles was already positioned near the back wall in a gray blazer, notepad out. We exchanged a brief nod. She was there as press, with the specific professional distance that role requires, and we'd both been clear about the boundaries throughout. Detective Garrett stood near the far wall, in a polo shirt and dark jeans, coffee cup in hand, looking as much like a Whispering Pines resident as a man with 18 years in law enforcement can look. Which is to say, reasonably convincing if you weren't paying close attention. At the front table, at the far right end, sat Barbara Ellison, retired judge, state-appointed election monitor. Her credentials were laid out in front of her in a neat stack. She had the absolute stillness of someone who has presided over genuinely difficult rooms and found all of them manageable. The smell of the clubhouse, folding chairs and bad coffee, and someone's floral hand lotion from close range. The sound of 22 people finding seats, the particular low murmur of a room that knows something significant is about to happen and is waiting for it to start. Diane arrived at 10:02. She was composed, I'll give her that. She worked the room the way she always had, the smile engaging and releasing with its fluorescent light precision as she moved toward the front table. I watched her process the details, the unusual turnout, Barbara Ellison's credentials, the reporter's notepad, the man in the polo shirt near the back wall she didn't recognize. I watched the recalibration happen, a barely perceptible adjustment, but she kept moving, because she had always kept moving, and 7 years of that momentum doesn't stop easily. At 10:04, Roberta walked in, separately from Diane, for the first time in anyone's memory. She took the seat at the opposite end of the front table. She unpacked a notepad of her own. She did not look at Diane. Diane noticed. I watched her jaw tighten, one small, involuntary press of back teeth together. Then she settled her clipboard on the table and prepared to run the meeting the way she had run every meeting for 7 years. Barbara Ellison opened the session first. She introduced herself, explained her mandate under ORC Section 1702.38, and described the election procedures that would govern the morning. Diane rose with a prepared procedural objection. She had a 2-page written argument about the Secretary of State's authority to compel elections of a private homeowners association. Barbara let her read the full thing. Then she said, in a voice of absolute calm, "The compliance letter was issued pursuant to Ohio Revised Code Section 1702.38. It is not optional or subject to internal override. Your objection is noted for the record. You may be seated." Diane was seated. The elections proceeded. Nominations from the floor. Vince Okafor for board president, Charlene Dupree for the first open seat, and Raymond Kowalski, 71 years old, Whispering Pines since before the first family moved in, 6 years of nodding in silence at meetings he should have been running, stood up slowly, straightened his jacket, and said, "I'd like to put my name in for the third seat. It's time." Then he sat back down. The vote was not close. Gerald voted with the room. At 10:41 a.m., Diane Pruitt was no longer the HOA board president. She sat very still. Then, in a voice she was controlling carefully, she announced an intention to challenge the election results and said her attorney would be in contact with all relevant parties. Oscar Tran stood up from the third row. "Miss Pruitt." His voice was quiet and entirely even. "Before you make any additional statements for the record, you should be aware that a federal civil complaint was filed on behalf of 6 Whispering Pines residents at 9:45 this morning." He cited the case number. He cited the statute, 18 U.S.C. Section 2511. The complaint includes documentation of the network interception device installed in this building's utility room and access logs recording an entry event to that room 4 days ago at 11:17 p.m., during which an unsuccessful attempt was made to extract or delete the stored data. The room didn't erupt. It went very quiet. That specific silence of a large group of people processing the same information simultaneously and arriving at the same conclusion. Diane looked at me. I looked back. I didn't say a word. There was nothing left to say. Everything that needed saying was in a filing, 23 pages long. Detective Garrett crossed the room, introduced himself by name and unit, and asked if Diane would be willing to step outside for a voluntary conversation. She went, not gracefully, but she went. Tanya Voiles was writing without looking up. The room slowly turned back toward the table. Vince sat in the center seat, the president's chair, with the slightly stunned expression of a man who had asked for something difficult and just received confirmation that it was actually real. Charlene's hands were folded on the table in front of her. Raymond Kowalski had an expression I still don't have the exact right word for. Settled, maybe. like something that had been at an angle for a long time had finally found its level. "All right," Vince said. He looked at the room, all 22 of us. "Let's talk about what actually needs fixing around here." The applause was not dramatic. 22 people in folding chairs on a warm Saturday morning, not a standing ovation. Not a movie ending, just real and earned and enough. I sat in the third row and let it settle. The legal proceedings ran through the rest of the year and into the following spring. That is the normal pace of these things, and I had planned for it. Diane's attorney negotiated a settlement in the federal civil case. The specific figure was sealed by mutual agreement, but Oscar described it to me as in the range that makes the exercise meaningful for all 6 plaintiffs. The Electronic Communications Privacy Act is structured to produce real consequences without requiring victims to calculate and prove specific financial damages, which is often impossible when the harm is privacy violation rather than monetary loss. Statutory damages of at least $10,000 per violation, available as a matter of law. This provision exists precisely because Congress understood that the most serious violations of privacy are often the hardest to translate into dollar figures. If you take one legal fact from this entire story, under 18 U.S.C. sections 2511 and 2520, victims of unlawful electronic interception can claim statutory damages starting at $10,000 per violation without proving actual financial loss. The violation itself is sufficient. This is available to anyone in this situation. The Ohio Attorney General investigation concluded with a consent agreement requiring a full independent audit of the HOA's finances and repayment of funds that had been directed to Pruitt Home Goods, LLC, over 4 years of transactions. The audit found $14,400 in misdirected funds. It was repaid as part of the settlement. The vendor relationship was formally documented and closed. Gerald, asked to provide a statement to the AG's office, described himself as largely unaware of the board's financial and operational decisions during his tenure, which was, in its way, the most accurate thing he had ever said at an HOA function. Roberta cooperated fully with every aspect of the investigation and was not personally named in any enforcement proceeding. She resigned from the board voluntarily the week after the annual meeting and sent handwritten letters of apology to each of the 6 families on the joint victim statement. Charlene mentioned to me some weeks later that Roberta had cried while writing them. I held that piece of information for a long time, without quite knowing what category it belonged in. The new board, Vince, Charlene, and Raymond, spent their first quarter doing things that felt genuinely remarkable only because they were so ordinary. Meeting minutes published publicly every time. Monthly financial summaries distributed to all residents before the following meeting. An open comment period built into every session before any vote. And a systematic review of every rule added to the CC and Rs since 2017, 17 of which were eliminated as procedurally invalid, including the home business registration fee, the light pollution addendum, the non-standard mailbox post requirement, and a regulation requiring all front porch furniture to conform to the craftsman style or equivalent that had apparently been there for 4 years without anyone questioning it. At the November board meeting, the first one held with a full resident audience, in a cleaned clubhouse with actual decent coffee, chairs arranged in honest rows facing each other rather than a single authority at the front, Vince announced that the HOA would establish a community technology fund, funded by a portion of the recovered $14,400. 2 purposes: subsidized internet service for the 4 senior households in Whispering Pines, whose residents were on fixed incomes and had been paying full retail for years, and an annual scholarship for a graduating senior from the local high school, pursuing a degree in computer science, network engineering, cybersecurity, or a related technical field. They named it the Whispering Pines Connected Community Scholarship. The first recipient was announced the following spring, a 17-year-old from Blue Ridge Loop, a family 3 houses down, that I had waved at for 2 years without knowing their names. She was heading to Ohio State in the fall for network security. She gave a short statement at the neighborhood's first genuine block party. Bounce house for the younger kids, Raymond at the grill in a Steelers apron, producing burgers with the confidence of a man who has opinions about charcoal. Callie in the grass with 2 friends, shoes off, that specific teenage posture that means contentment.
The girl said she'd always been interested in how networks worked, but hadn't thought of it as a career until she read the Dispatch article about Whispering Pines, and decided that building systems to protect people's privacy, so no one else has their most private searches sitting on a stranger's USB drive, seemed like exactly the right work. The grill smoke drifted across the cul-de-sac. Callie caught my eye and gave me the look that means, "This is okay, Dad." I noted it in the category of things that matter. Vince walked over and stood next to me. "No beer this time. Play stupid games," he said. "Win stupid prizes," I said. We watched the neighborhood for a while. It looked, for the first time since I'd moved in, like what it was supposed to be.
$47,000, a resignation letter, and a guilty plea. That's how it's ended for Vivian Brad. Here's what I keep coming back to with Decker's story. He didn't win because he got lucky. He didn't win because he got angry. He won because he's opened a folder, picked up a phone, and spent 4 months being more prepared than the person coming after him. The bold cutters, the fake company, the smear campaign, none of it worked, because every single move she made, he already had a response waiting. That's not revenge, that's patience with a paper trail. And look, most of us will never deal with a Vivian Brad, but a lot of you have dealt with someone who thought a little bit of authority made them untouchable. So I want to ask you generally, what would you have done differently than Decker? Would you have held back the same way he did? Or would you have swung earlier? Drop it in the comments, I read them all. And some of you have stories that honestly belong in their own video. If this one hit home, subscribe. We put out a new story every week. And they only get more satisfying from here. Next week, a city council invokes eminent domain to take a mass workshop. What they didn't check was the 1912 disc sitting in the county archive. You're going to want to see how that one ends. I'll see you then.